Well, as you know, we've been reporting that the Constitutional Court has agreed to hear former President Jacob Zuma's rescission application. It will be heard virtually on the 12th of July. There's a lot of buzz around it. There's a lot of disagreement between legal people about whether it's the right thing to do or not and what the consequences might be. Let's unpack some of this with human rights lawyer Richard Spoor. Richard, you were on Twitter this morning. Thank you for joining us. You were on Twitter this morning saying some very interesting things. People might consider some of it controversial. I'd like to go through each of the different points that you made to try and understand better, to get from you the full explanation. So your first point was that the handling by the Constitutional Court was actually a comedy of errors, and they should have dealt with it differently from the first time that Zondo directed his appeal to them to try and deal with the fact that the ex-president wasn't appearing. Just take us through that. Appearing in front of him, yeah.
So when Zuma refused to appear before Zondo Commission, and refused to honour the subpoena, Zondo appealed to the Constitutional Court. The Constitutional Court agreed to hear the matter. Zondo's reasoning was that he had to go to the Constitutional Court because he was running out of time, and if he went to the High Court, Zuma would appeal and cross-appeal and goodness knows what, and wouldn't happen. So he appealed directly to the Con Court. The Con Court agreed to hear the matter and ordered Zuma to appear. But there was criticism at the time. There were some of the judges who said, we should not have entertained this. We should have left it to the High Court. They should take the decision, and we can deal with the appeals that come from it. But they didn't, and they made the call, and they directed Zuma to appear. So that created a problem going forward, because who do you appeal from if you wish to challenge the Constitutional Court? And typically, a right to a trial includes a right to an appeal. An appeal also guards against the possibility of mistakes. And in this instance, there is a possibility that the court may have made a mistake.
Let's try and understand that then. You say there's the possibility they made a mistake, which is, I'm assuming you're saying that on the back of the fact that they've accepted his rescission application and they're willing to hear him on the 12th of July. Take us through what the mistake was, or what the mistakes might have been.
Well, at the heart of the controversy is the difference between the judgment of the majority of the court and the minority. The minority said, look, Jacob Zuma is guilty of contempt, but this warrants a trial. Refer the matter back to the Director of Public Prosecutions, instruct him to prosecute Zuma, and try him in the ordinary course like any other accused who's charged with the contravention of the crime. The majority decided that that was not appropriate. So even though Zuma didn't appear before them, didn't give reasons about why, what kind of sentence should be imposed, failed to participate, the court said, well, fine, in those circumstances, you're not participating. We're imposing a sentence that we think is appropriate, and imposed a sentence of 15 months. Now what Zuma is doing is saying, no, there's been a terrible mistake. I really didn't have the opportunity to come in front of you because I was sick and I had no money. But I would have liked to come before you. I would have liked to tell you that I'm really old, that I'm very vulnerable, that if I go to prison I can get sick and die. I would have said these things, and if you had heard me say these things, you may have come to a different conclusion about what to do with me. They also pick on the fact, they take up the minority judgment and say, Zuma picks up on the minority judgment and says, what you're doing is you're violating my constitutional rights, as the minority decision says. So this leaves the court now in a very difficult position. Should they hear him and allow him now to raise his defense, which requires them to actually believe that he didn't come before them, not because he just was contemptuous of the court, but because he honestly didn't have any money. He honestly, had no opportunity to do the thing. He was sick.
Richard, let's focus in on what you're saying, right? The arguments that is being made on behalf of the ex-president right now, all of that, one assumes, would have been considered when the minority and the majority, when they were debating these issues, because as you say, the minority had some points of view that they put forward, etc., it would have all been thoroughly debated before the vast majority of justices decided that they would rule in the way that they did. So it's not like any of the information that you're talking about right now that is being put forward by the ex-president is new. They would have been aware that he, has talked about illness before. They have seen and are aware, like all of us are, that there are questions about affordability. So none of this is new evidence, and it surely would have come up in a debate as the justices were considering all of the possible implications, because they understand the seriousness of the issue that they're dealing with. It doesn't sound like there's anything new here.
Well, the fact of the matter is that the court offered him an opportunity. It said, "Dear Mr. Zuma, please contribute. Please tell us what you think is an appropriate sentence and why. Give us the facts, give us the circumstances." And Mr. Zuma didn't do that. Now, the court believes, well, it's a general principle of law. If you're given an opportunity to say something and you don't do it, you don't take that opportunity, well, you've lost your opportunity. And so there are two possible outcomes. The one, which certainly seems likely if you look at the attitude that the court has adopted and the majority adopted, is going to be, look, we've given you your opportunity. You're not raising anything new. You're not saying anything new. In any event, these are things you could have said earlier. We persist with the sentence. But there is a problem. He is 79 years old. He is sickly, and 15 months is a very harsh punishment. So do you give him a hearing? Do you give him an opportunity and say, well, okay, in the circumstances, we'll reduce it to 3 months? That is awkward. Also, they need to bring it back within the parameters of the law of a rescission application. Now, a rescission application is brought on two bases. One, the person was absent, which applies here because Zuma wasn't there. So he didn't get a chance to say his side. But two, there must be some material error or misdirection on the part of the court. You need those two things. So how is the court going to try and justify giving Zuma a hearing and amending its own decision and perhaps reducing the sentence or suspending it? How does it justify that? They are riding on the minority judgment to bring that home, but that is probably not enough. But the fact remains that things have gone so far that the former president faces an extremely harsh sentence and has created a very difficult situation for the court to deal with this and to accommodate his ill health and his age.
Richard, when you speak about age and ill health, it almost sounds like if one accepts that there is a shift in position because of those two arguments, then we're open to anyone who's old and unhealthy always looking for some kind of leniency. And of course we saw this even with the Shabir Sheikh matter. When he was on death's door, he was let out. I mean, this sounds like it's repeating itself.
Well, not really. Remember, the minority judgment said, try him, put him in front of a criminal court, drag him there, charge him. He must plead guilty or not guilty. Evidence must be led, he must be convicted. Once you're convicted, you turn to the accused and you say to the man in the dock, what's your defense? What are you saying about an appropriate sentence? And then Zuma has the chance to say, well, he's standing in the dock, he has to say something. He says, I'm really old and I'm sickly. Now, that didn't happen. He wasn't in front of the court. He wasn't dealt with through the criminal process. So we can't say yes. He failed to present his case when he was invited to do so. But on the other hand, perhaps this matter should be dealt with as a criminal matter, in which event Zuma would have been physically present and would physically have had to say, I have something to say about this 15-month sentence, or I don't. Now, the Constitution leans very heavily towards the right to a trial. The right, it demands, it doesn't matter if you're guilty or not guilty, how bad you are, it demands that you appear in front of the judge and you get the chance to say your say. Zuma didn't have that chance. It's his own fault. It's a problem of his own making, but I think it's a very uncomfortable position for the court to be in, to have sentenced a man to 15 months imprisonment without having him physically in the court and answering the question.
But at the same time that you're saying that, you also quite correctly are saying this is not because the court didn't afford him multiple opportunities to present himself there, and he didn't. He chose to ignore that, and that is ultimately where we are, the contempt and the fact that he persisted in that way, in that approach.
You're probably right. I mean, I think, on balance, that is quite likely what the court's going to do. They're going to say to him, you had your opportunities, you squandered them, you refused to participate, your failure to participate borders on contempt. It's too late. The court has made its decision. We're bound. We see no reason to change our decision, and your crying after the fact is simply not sufficient.
Richard?
And confirm.
Yes, go ahead. There's one more thing that I was very intrigued by in your tweets. One of them says the majority judgment was emotionally inspired. You said they were angry, and that's why they behaved in that way. That's quite a thing to say to the Constitutional Court and its majority judgment. What particularly in that judgment seemed to imply to you that this was emotionally inspired, that they hadn't behaved rationally? Because, you know, that's the opposite of this anger.
No, I think the court was very, very firm about its duty to defend the constitutional order and the rule of law. I think the court took, and they emphasized the point that they were extremely dissatisfied with Jacob Zuma's conduct, his public statements and utterances. It's significant that Zuma tries to distance himself from that now. Now he says some of these statements were made by the Zuma Foundation. So this is a mistake he's relying on. He's saying to the courts, you made a mistake. You assumed I said those things, but in truth I didn't. It was the Jacob Zuma Foundation. And to the extent that you took that into account, you have committed a material error of fact. No, the majority ruling was very firm, very clear, very straightforward. We are defending constitutional democracy. We condemn his conduct, and that's reflected in the sentence of 15 months. 15 months for contempt of court is unprecedented. I cannot think of an instance where anybody has ever been sentenced to 15 months for civil contempt. A typical ruling is in the range of 30 days, but as you know, we're aware in the debate, that is typically used as a coercive measure. We're not talking coercive here. We're talking about a punitive measure for contempt of court. It's extremely rare. It seldom happens. But 15 months is an indication that this court felt that this was a very, very severe provocation on the part of Jacob Zuma, a very severe challenge to the constitutional system, and that a very firm response was justified. They clearly felt this is really important, and in these circumstances, a harsh sentence is justified.
And so if you were to make some kind of prediction, sorry to force you in this way to think about the 12th of July, do you think that at best Zuma can expect a potential reduction in the time that he needs to spend in prison? What would you say?
I think that's the best possible outcome for Jacob Zuma, that his sentence is reduced. I think, however, that it's more likely that the court is going to sustain this verdict.
Thank you.
But my point, however, is not what the court does. My point is that it is unfortunate that we're in a position now where Zuma has been tried and sentenced in absentia, doesn't have a right to appeal, and the penalty is extremely harsh. And if that is upheld, well, that's fine. That's the law. It's the highest court. It's spoken. But it does raise questions and doubts about the procedure that the court has followed and its own judgment in the way it has dealt with this matter. And I think there are questions. And as a lawyer concerned about upholding the rule of law and our constitutional democracy, I would have liked to see fewer mistakes on the part of the court. I don't like the fact that we're facing the situation that it's a showdown one way or the other, I'm concerned that justice might be the loser.
Those are your views. Thank you very much for your time. Human rights lawyer Richard Spoor.